Now call the first case on this morning's docket. Case number 114951, State of Kansas v. Scott Bacon II.
Mr. Chief Justice, may it please the court, Cooper Overstreet, attorney of the Swain Law Office, appears on behalf of the petitioner Scott Bacon. Mr. Chief Justice, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. In September 2015, Mr. Bacon was convicted of 1 count of commercial sexual exploitation of a child after a jury trial in Sedgwick County. On appeal, Mr. Bacon raised several issues. The Court of Appeals affirmed Mr. Bacon's convictions. Mr. Bacon petitioned this court for a review of one specific issue, whether the Court of Appeals erred in holding that Mr. Bacon's pro se motions failed to trigger the trial court's duty to inquire into Mr. Bacon's dissatisfaction with his attorney. A brief factual background of the trial court proceedings. Mr. Bacon had his first appearance in Sedgwick County on August 7, 2014. He was in custody at the time. On August 11th, 2014, he was appointed an attorney from the Public Defender's Office. Mr. Bacon's preliminary hearing was then continued 7 times at that point, without any court appearances being had for these continuances or any records being made of these continuances. Finally, on December 1st, 2014, Mr. Bacon filed with the clerk of the district court a pro se document entitled Motion for Diligence. In this document, which was a handwritten document, Mr. Bacon cited the Kansas Rule of Professional Conduct 1.3, which cites diligence. After receiving no response from the district court, Mr. Bacon then refiled the same handwritten document, and he once again titled it Motion for Diligence. At that point, he did receive a response from the district court.
What was the time between that? We had December 1st motion, no response, and then a second one. When was the second one filed?
December 8th, Your Honor, so roughly a week that Mr. Bacon filed this new motion.
And was it a copy or did he rewrite it out? Do we know?
From the record, it appears that it is a copy. In response to Mr. Bacon's second filing, the district court sent out a letter to Mr. Bacon, his appointed attorney, and the district attorney. This letter, which is part of the record, indicates that the district court informed Mr. Bacon that they had received his documents and that no further action would be taken on those documents, and that a copy had been forwarded to Mr. Bacon's attorney and the district attorney's office.
Excuse me, counsel. In answer to my colleague's question about whether this is a copy, what I have in front of me appear to be 2 different documents. The first one has no heading on it. The second one has in the District Court of Kansas, 18th Judicial District. My question is, if that's correct, does that make any difference in your presentation or your argument?
No, it does not, Your Honor. I believe that both documents contain substantively the same request for purposes of my argument. At the time that Mr. Bacon then received the document from the district court, no further action was taken on those requests that he had sent in. 4 more continuances of his preliminary hearing occurred until February 19th, 2015, where Mr. Bacon had a preliminary hearing. After that, Mr. Bacon's case was set for jury trial, and eventually Mr. Bacon hired a new attorney and substitute counsel entered her appearance on September 3rd, 2015. First, the principles of law that apply to this argument. As a matter of law, the district court has a duty to safeguard a defendant's Sixth Amendment right to counsel at all stages of the proceeding. However, it's true the Constitution does not guarantee a criminal defendant a right to counsel of his or her choosing If a defendant seeks substitute counsel, he or she must show justifiable dissatisfaction with his appointed counsel. The defendant bears the burden of showing an articulable statement of dissatisfaction, which will in turn trigger the district court's duty to inquire further. In this instance, the Court of Appeals...
Counsel, even if that duty was triggered here and the court erred in failing to inquire in response to those two motions filed pro se, where does that get you, given that he eventually retained his own lawyer, and I'm correct, right, that lawyer represented him through trial?
You are correct, Your Honor.
So what's the prejudice to him or harm?
Well, without the hearing on the duty to inquire, obviously the purpose of the duty to inquire being to investigate a possible conflict between Mr. Bacon and his counsel.
Get him a new lawyer quicker than he got one, right?
That could be a purpose of the hearing. Obviously, if
That
Mr.
was
Bacon...
probably his purpose, either speed this one up or give me a new one, right?
It is a motion for diligence, so one can assume that Mr. Bacon himself was requesting diligence in his attorney's actions on his case. If that conflict were to be found to exist at that hearing, in that inquiry hearing, Mr. Bacon then had a hearing, he had a preliminary hearing after that, after he filed those motions. Could very well be that Mr. Bacon had conflicted counsel throughout a majority of his case. Obviously, he's entitled to representation of counsel throughout his entire case in every crucial proceeding.
And the remedy, back to my colleague's question, what would the remedy be? To go back and have a new trial with another attorney, but he had a trial with another attorney. I think the question is how can we remedy when he had self-help remedy?
Well, I guess we need to look at how much he helped himself by retaining that new attorney. Mr. Bacon retained that new attorney about 2 weeks prior to when his case was set for trial. That new attorney entered her appearance on the case and then requested a continuance, which was denied. Obviously, preparations for the trial could have been affected by that attorney having entered their appearance so short in time.
I'm sorry, I was going to ask a question. Complete your thought, please.
Mr. Bacon's understanding, or at least the conflict that he had with his counsel in his mind, was so severe that he chose to retain an attorney with his jury trial only 2 weeks away. The prejudice being that it's likely that attorney was not fully prepared for that trial, and that this sort of a cascading effect of...
You're not pointing to any particular errors by that counsel, are you?
I'm not pointing to any specific errors by that counsel. I'm specifically citing the fact that Mr. Bacon, forced to go with conflicted counsel for as long as he did, led to that counsel being possibly not prepared to go to trial in that case.
Is there any allegation that the new attorney was unable to hire an expert or do any investigation or discovery that was anything that was foreclosed as an avenue for preparation?
There's no specific allegations of not hiring experts. There were numerous motions that were filed, that are in the court file, that were filed by the attorney basically right as soon as the appearance was entered, within a week of the appearance being entered, that were denied summarily by the district court because of their untimeliness. Those included motions that, some of them substantive, motions for evaluations of the alleged victim in the case, things of that nature. That in itself obviously could lead to some sort of prejudice against Mr. Bacon in that he's filing substantive motions, attempting to have those heard by the court, but the court's on one hand saying we're not continuing your trial, and then the other hand saying we're not allowing your new retained attorney to even argue these motions. Mr. Bacon having his attorney enter the appearance at that late date because of this potential conflict and this notice that he had given the court months prior, that's the prejudice that obviously occurred in this case. Now, the question the Court of Appeals reached was, or the holding they reached was that this did not constitute in the first place an articulable notice of dissatisfaction. Clearly, the court has the document in front of it. The first item I would cite is that this is a motion, Mr. Bacon titles it Motion for Diligence, and it cites the Kansas Rules of Professional Conduct. Specifically the rule of professional conduct dealing with the representation of an attorney and his client, requesting diligence. This was not a rule that dealt with the district court's conduct or judicial conduct. This was a rule that dealt with the representation between him and his attorney, obviously indicating that Mr. Bacon himself was requesting diligence from his attorney and that an issue
Meaning what? I mean, the court gets this motion for diligence that cites a rule, and the criminal courts get a lot of pro se motions, and almost all of them are a little more specific. Maybe they lack citing to some specific case or something in the record, but usually the complaint is articulated. Here it's just a rule. And if I were sitting there as a district court, what is this? And what is the duty to inquire on something that's so generic and non-specific? I don't understand what the court could have done with this other than what it did, and just waited and see how the case would evolve, because there's nothing, as far as I can see, there's nothing there.
Your Honor, I think this, to answer your question, I think this could have been remedied by having, and I think we need to look at the context of Mr. Bacon's case as a whole and the way that it played out through the court system, and that from the time that Mr. Bacon had his first appearance to when new counsel entered their appearance in September of 2015, the record shows that there was one hearing that was held where Mr. Bacon was actually present in the courtroom and able to actually confer with the court if need be.
What prevented him in his motion from, again, I appreciate these are pro se litigants, some with more sophistication, some with less, but just articulating what the concern is other than citing to a rule. Saying, I haven't met with the guy. You're saying there's a conflict. This doesn't articulate a conflict. I suspect he's concerned more about the pace of the case. And he's sitting there, but you just don't know.
Well, I think that when Mr. Bacon receives a response from the district court saying no further action will be taken on his motion, that in and of itself places a sort of chilling effect on Mr. Bacon's sort of idea of how the court is being responsive towards him. If he's getting a letter from the court saying, we've received this, we don't think you're telling us anything, and we're not going to, take it any further, then it follows that Mr. Bacon wouldn't file any further motions from there. The court's correct in that this is a pro se pleading to be construed liberally, and Mr. Bacon is not an attorney, and that's why pro se pleadings are construed liberally. I would also say that this request happened at a point where Mr. Bacon's preliminary hearing had already been continued 7 times. This was not a request that he made right off the bat, and he's not an individual who was making multiple requests to the court or filing overly litigious motions with the court. This occurred when his preliminary hearing had been continued out almost 4 months from his first appearance. So if the district court had inquired further, it's a possibility they could have deduced that Mr. Bacon did have a conflict with his counsel, a conflict that it doesn't just have to be a conflict per se, obviously. It could be a breakdown in communication. A request for diligence on Mr. Bacon's behalf could be that he's requesting diligent communication from his attorney and that his attorney hasn't communicated with him. Obviously, that's not something that's in the record because the inquiry did not occur. And that's obviously in this case that we argue that this was a notice of dissatisfaction that triggered that duty to inquire, and there was no inquiry that occurred. Quite possibly the correct remedy would be to remand this case obviously back down to district court to have that hearing to determine whether or not Mr. Bacon was actually conflicted by his counsel, and that would be our request. If the court has no further questions.
We have no more questions. Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state of Kansas. The single issue before the court this morning is whether the district court abused its discretion in failing to conduct a specific inquiry into the pro se motions that were submitted by the defendant in this case. This court has repeatedly held that the defendant bears the responsibility of providing an articulated statement of dissatisfaction, which will then trigger the district court's duty to inquire into a potential conflict. Here, within a week, defendants simply submitted 2 copies of KRPC Rule 1.3. What defendant now characterizes as...
Excuse me, counsel, but
Yes.
wasn't that captioned by the phrase motion for diligence?
The second one was yes. Actually,
Both of them were.
yes, both
So,
were
so doesn't
captioned.
that give some notice when you caption what you're seeking?
Well, typically, this court has required something more specific. And the content is what controls when we're talking about liberal construction of pleadings over the captions. So this court has typically looked for whether there is a statement regarding a conflict, a irreconcilable disagreement, or a total breakdown of communication. When we look at the defendant's motion against that backdrop,
But isn't the question whether the court had a duty to inquire whether those things happened? And whether this, when you receive a motion for diligence and the KRPC rule that requires counsel to exercise diligence, isn't that a red flag?
To me, I guess I would side with Justice Rosen on this in that it is not a specific articulated statement of dissatisfaction. It is recopying the rule, which could mean any number of things. Is it based on, has counsel treated this as an inconvenience? Has he had a lack of commitment or dedication? Has he not exercised his professional discretion? Is his workload out of control? There isn't a specific articulated statement of dissatisfaction, as the case law from this court has indicated triggers the duty to inquire.
But in context, there had been 7 continuances of a preliminary hearing, and the preliminary hearing precedes arraignment, and arraignment's what triggers statutory speedy trial right. Is there any strategy involved in 6.5 months delay in preliminary hearing?
At this time, at the time these motions were filed, counsel had only been on the case for 3.5 months. So in an
But
assertion...
we're talking about a preliminary hearing. We're not talking about preparing for trial. We're talking about a preliminary hearing, aren't we?
Yes. But that would still require a fair amount of preparation, considering this one went to a full evidentiary preliminary hearing. This was not a situation where preliminary hearing was ultimately waived. Even if this court were to determine that the motion was a sufficient catalyst to trigger an inquiry, the appropriate remedy ordinarily is to remand the case for a determination whether the purported conflict adversely affected counsel's performance at trial. So the overarching inquiry is to protect that Sixth Amendment right to representation. But here, defendant ultimately retained counsel of his own choosing and proceeded to trial with that attorney. Now, the assertion has been made that those multiple continuances ultimately adversely impacted counsel's ultimate representation because of the delay. The state would take some issue with that based on the assertions that were made at the motion for continuance when ultimately retained counsel informed the court that she had been in discussion with the family for multiple months but had not been retained because the funds had not been available. So this was not simply a matter of continuance is what delayed my representation. There is some sort of indication that the delay in her retention was because of defendant's inability to acquire the funds to retain her. So the continuances are not the sole reason for the delay.
But if there had been inquiry and there was a determination that there was justifiable dissatisfaction, then there would have been a duty on the part of the district court to appoint another attorney. And there wouldn't have to have been funds gathered up to hire an attorney, because there would have been a different attorney, right?
We don't know that. Because we don't know whether the hurdle would have been cleared that Mr. Bacon could have shown justifiable dissatisfaction.
I understand that, but my point is that if it had been successful, then there would have been a court-appointed attorney. And so your argument that the delay was solely because of gathering the money may or may not be true.
We don't necessarily know that he wanted substitute appointed counsel. The record seems to indicate that he wanted to retain counsel of his own choosing. There's never been a mention that he wanted substitute counsel appointed. So we can't speculate that that's what would have happened if he had been successful on what is ultimately a non-existent claim of a conflict.
But isn't that why we have a duty to inquire? I mean, I guess I just don't understand how much prompting it takes to get a judge who has a duty to just ask what's going on. I mean, I've been pretty, hard on defendants when it comes to this kind of issue, but that's always come after the judge has asked what's going on. And here you've got two different motions going on, and I just can't get past this. What's wrong with the judge just finding out what's going on, asking the defendant? Then you don't have all this speculation.
True, you don't. However, that's where we find ourselves now. So the point is, the court didn't inquire. We don't know why the court didn't inquire. It would be the state's position that the motion wasn't specific enough to trigger that duty. So where do we find ourselves now in the absence of that lack of inquiry? And the remand would essentially be ineffective because he had an attorney of his own choosing. So there was no adverse effect at the
Counsel,
time.
did you make that kind of harmlessness argument in your brief?
I did not make that argument in the brief because the only way the issue was raised was whether there had been a sufficient trigger for the duty to inquire.
But isn't harmlessness typically, the demonstration of harmlessness is typically falls on the side of the party that benefited from the error, which would make it the state's burden here to show harmlessness?
I guess I wouldn't necessarily say that it's a harmlessness inquiry. It's a lack of a satisfaction of the test.
Well, how is that? You can call it lack of prejudice, I guess, which is kind of the flip side of the same coin.
It would be an absence of, well, I guess you would say lack of prejudice, an absence of a showing by the defendant that he sustained prejudice. I don't necessarily think that's the same side as showing harmlessness.
So you think that in order for the defendant to prevail on his claim that the district court abused his discretion, the defendant has to demonstrate prejudice?
That is what the case law seems to indicate. The case law indicates that he has to show a conflict and that his trial was adversely affected.
That's to get new counsel,
Right.
not to get an inquiry. And I don't see in the case, help me out, I'm not sure I see in the case law an element of this particular claim that the defendant showed prejudice, because that's putting the cart before the horse. The defendant in this case is saying, I didn't even get an inquiry.
I guess my point is to get the relief he seeks, which
Yeah,
is
but that's a harmlessness argument, isn't it?
I suppose, yes.
And that gets me back to my first question. How can we consider that? Make your best argument for why we should consider the harmlessness of this alleged error.
Okay, so the case law indicates that it is an abuse of discretion when the court fails to inquire. That does not necessitate that he receive the new trial that he's requesting simply because the court failed to inquire. In order to get to that point, the defendant has to show that there was a conflict and that conflict adversely affected the trial. It's the state's position that burden cannot be established. So it would be our argument that he cannot acquire the relief that he seeks based on the record before this court.
I mean, I'm just trying to figure out the category for that. Is that a mootness argument?
No, it's just
You're saying even if everything he says now is true, when it goes back, it's outside the realm of possibility that he could ever demonstrate prejudice because he had a trial with a new lawyer.
he cannot demonstrate that it adversely affected. He cannot demonstrate that the representation he received at the preliminary hearing had an adverse effect on the verdict, which would be what his burden is to acquire the relief that he seeks based on what he has before this court.
I understood counsel from your opposing counsel when we were pressing him for some showing of prejudice or lack of harmlessness, however you want to characterize it, that he was saying new counsel filed some motions that were denied as untimely by the judge. And I thought inherent in what he was saying is that they were untimely because of all the continuances and then her late arrival on the scene, and the time was really short past deadlines. Is that your understanding?
So those motions were, okay, she'd been on for 2 weeks. Those motions were filed after 5 p.m., after her motion for continuance had been denied. So those were 18 motions that were filed after 5 p.m. on the Friday preceding trial, after her motion for continuance had already been denied. So there had been no effort in that 2 weeks that she had been representing him to file those motions. It was only after the continuance was denied that she then filed this bevy of motions.
And it's your position that she could have and should have filed those before her motion was denied?
Correct.
Going back to just the motions themselves or the notice of diligence themselves, we have case law that says if there has been a disciplinary complaint filed or disciplinary complaint made, that is sufficient to require the judge to make an inquiry.
Yes.
Why is this different when the essence of the motion is to cite to a Kansas Rule of Professional Conduct and essentially say, I want my attorney to meet their ethical standard?
Because when an ethical complaint has actually been filed, there is a factual foundation that could necessarily be offered to substantiate that claim. And we don't have that here. This would be akin to submitting a disciplinary complaint with no body, no argument offered in support of that claim. There simply is not anything here to substantiate a colorable claim or a demonstrable claim of justifiable dissatisfaction, as there would be with a fully completed disciplinary complaint.
Does the state ever have a responsibility to flag issues that might cause problems later if there's a conviction? Seems like this would be one where if I were the prosecutor, I might say, Your Honor, we got this thing sitting out there. Don't you want to at least ask what's going on? What prevents that?
There isn't anything that prevents it. That would presuppose that the attorney assigned to the case has actually had an opportunity to see it at that point. When the assertion is made that the district court circulated this, it was actually the district court clerk. If at the time they proceeded to trial that the prosecutor was aware the motion had been filed, sure. Is it a better practice? Probably. But is the absence of that practice enough to say that reversal is required because the verdict is unreliable based on the court's failure to inquire into this motion? And that showing simply has not been made. If there are no further questions from the court, the state would respectfully request that the Court of Appeals decision affirming the district court be affirmed in this case.
Thank you, counsel.
Thank you.
May I proceed, Mr. Chief Justice?
Yes, please proceed.
Thank you. Just a few statements in response to counsel's arguments regarding the motions. The newly retained attorney. It's important, I believe, for the court to look at the situation that Mr. Bacon was placed in when he retained that new attorney. I'm sorry. Up until that point, Mr. Bacon had nearly no substantive motions filed on his behalf. This is in addition to these motions for diligence that he had, like I said, filed with the court months prior. The district court denied the new attorney's motion for a continuance. It was at that point those motions for a continuance were denied, that those new motions, those pretrial motions and some substantive motions were filed. I think it's unreasonable to think that a new attorney would file those motions or even be prepared to file those motions at a 2-week time period from entry of appearance to filing those motions is a quick turnaround. So to say that...
Counsel, based on that argument you just made, are you agreeing or conceding that in order to get a new trial, your client will have to demonstrate prejudice at some point?
Your Honor, I would agree that a hearing, a duty to inquire hearing would need to be held, but at that point, if a conflict or some sort of conflict were found to be in existence at the time that Mr. Bacon filed those requests, at that point, he's with conflicted counsel. He's being represented by a conflicted counsel.
Well, are you arguing that your client can get a new trial without ever demonstrating prejudice?
Your Honor, I think his Sixth Amendment right to counsel would be infringed if...
Does that get him a new trial?
I think that it could get him.
I mean, if that's your argument, why are you? I mean, you're arguing factors of prejudice. In other words, the new attorney wasn't there on time, didn't have enough time to prep, couldn't file motions. Those are all arguments about prejudice, right?
They are, and I think either way he was prejudiced. I think that his prejudice was from the fact that he worked to retain a new attorney.
Let's say that we disagree with your conclusion that the Sixth Amendment violation is enough per se, that there has to be a showing of prejudice at some point. What is that point? Like, is that for us to decide whether or not there's demonstrated prejudice, or does that happen somewhere else?
I think without the court knowing specifically what the conflict was, or without this court knowing specifically what the conflict was, that demonstration, this court can't decide that demonstration of prejudice. I think at some point, if a demonstration of prejudice is decided, it would be based off of what specifically that conflict was.
Counsel, I had a follow-up question. My understanding of your argument is that the pleadings alone that were filed by your client were enough to trigger the duty to inquire by the district judge, correct?
Correct.
And assuming we don't accept that argument, is your next argument that the court had an obligation on its own to look at the record and learn that there had been 7 continuances or a number of continuances, and that could be the basis for these pleadings?
Your Honor, I think that it's problematic in a system where these continuances are occurring and Mr. Bacon isn't being brought in, which for these hearings on these continuances, I then think that places an added weight on the court to, when these pro se pleadings are received, to give them deference and to look at them in more detail, specifically because these defendants, like Mr. Bacon, aren't being brought in. And so I do think, yes, that the court then does have a duty in this specific system that was in place at the time for Mr. Bacon's case to give deference to those pro se pleadings and to really consider them and not simply provide form letters out to the defendants after the pleadings are filed.
Counsel, can you just refresh my recollection? The time between the filings, I think you said December 8 was the last of the 2 motions.
Correct.
And what was the date again? How much longer did it take to get the preliminary hearing?
The preliminary hearing was February 19th of 2015.
Okay. So the period of time, well, and then after the preliminary hearing, counsel stayed in the case until about 2 weeks before trial.
Roughly.
And how long was that between preliminary and that 2 weeks point?
Your Honor, New counsel entered her appearance September 3rd of 2015.
Okay, so December 8 to September 3rd. And what should have been taking place in that time period that did not take place?
Well, a preliminary hearing took place.
Yeah, I'm
Invest-
asking about what didn't happen that should have happened. I'm still trying to drill down to what did this cost your client, even if we assume that the duty to inquire was breached.
Well, obviously, investigation. These were very serious allegations. Investigation, whether through using a private investigator to investigate the alleged victim in the case, filing of motions. I think after the preliminary hearing, as I said, when new defense counsel entered her appearance on September 3rd, there had been, I believe, one motion that had been filed, which was filed in the days preceding defense counsel entering her appearance, was a request for a Jackson Deno hearing, which was a form request for a Jackson Deno hearing. No other substantive motions had been filed. No motions like the motions that new counsel filed requesting evaluation potentially of the alleged victim, things like that. So I would argue those were things that could have been done by appointed counsel during that time period. If the court has no further questions, I would ask the court to consider our briefs. Thank you.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.